What do California laws about chickens have to do with Missouri farmers? More than you might think. There are a lot of other legal issues that can affect Missouri agriculture. We're going to visit with Attorney General Chris Koster about a few of them. Next on Show Me Ag. Welcome to Show Me Ag. I'm your host, Kyle Vickers. Thanks for joining us. Legal issues and regulations can have a dramatic impact on Missouri farmers. In one example, California voters passed a law regulating the space granted to hens in an egg-laying facility, and soon all eggs sold in their state have to come from growers using the same methods. This has become a problem for growers in Missouri who want to sell eggs in California, and it may become a constitutional issue about interstate commerce. Our guest tonight is our Attorney General, Chris Koster, who is suing California on behalf of Missouri producers. Thank you for being with us. I know you have a very busy schedule. I really appreciate you coming.
It's good to be here.
How did you come about getting into this lawsuit? It seems kind of an obscure thing, but it's an important issue, isn't it?
It is an important issue, and the issue was brought to us by a number of folks in the agricultural industry here in the state of Missouri, and I had been doing a little bit of reading after I learned about it through those conversations. And it became pretty clear that we had what I thought was a major constitutional argument that had to be brought to the forefront. It's unfortunate to some degree that this issue is so intertwined with the animal welfare issue, because that in a sense confuses what the core of the matter is. And the core of the matter is that the California legislature is trying to regulate agricultural production here in the state of Missouri. This case has to do with egg production, but it could affect the corn industry, the soybean industry, any aspect of agricultural production in our state.
If it affects a big user like egg production, it affects corn and soybeans directly anyhow, doesn't it?
It sure does, because of the feed that goes into it. But this is a principle that we are trying to stand up for here in the state of Missouri, which is that the California General Assembly cannot regulate agriculture in the state of Missouri or in any of the other 49 states.
Let's get a sense of how Missouri's egg producers feel about this new law. We traveled to Columbia, Missouri to visit with Jo Manhart of the Missouri Egg Council. She's been dubbed the Egg Lady, and she volunteers her time as she travels across the state advocating for the egg industry in Missouri.
When I was born, my dad drove a chicken truck for MFA in Shelbina, Missouri. So maybe I was supposed to be in the egg industry. And then my husband lost his job in California as an aerospace engineer. So I went to work on a chicken ranch. They call them chicken ranches out in California. And so for 2 years, I worked on a chicken ranch. I was in the office answering questions, but I thought the industry was very high-tech and interesting, even back then. So when we came back to Missouri, he finally got a job after a year and a half, and it was in Columbia, where it's just where both our parents are. So we came back, and I saw an ad in the paper. Missouri Egg Council is looking for an executive director, travel required. My youngest was 16 at the time, and I thought, I can do that. So that's what I've been doing since '76. So California passed in 2008 a law which says laying hens need to be able to sit down, stand up, turn around, and spread their wings without touching anything. Okay. It didn't say how many square inches they needed to have. It didn't say cage free or anything. It just said that. Well, already chickens can lay down, stand up, turn around, and if 3 chickens go to the back of the cage, 1 chicken can do a waltz all by herself out in the front of the cage, but they tend to clump together. So the California producers were bound to abide by this, which was going to cost them, by California's own estimate, several $1 million in lost taxes to the state of California, not mentioning the several million dollars that each producer was going to have to get. I understand now that California imports about half of their eggs, so they, said, wait a minute, if we have to abide by these rules, why doesn't everybody? So California passed a law that all eggs coming into the state, beginning next year, January, have to be raised in the manner that the Humane Society described, which nobody is quite sure yet what it means because it says exactly what I said. Does that mean they all have to be not in a coop, or does that mean the coop has to be bigger? Nobody knows. I don't think it's fair that a group that knows nothing about how farming is done can impose this kind of chaos on the marketplace. The suit, as I understand it, and I have read it, but you don't always understand what you read in lawyer lingo, is that by imposing standards on eggs coming into the state, California is violating the Interstate Commerce Clause of the U.S. Constitution, and I believe that.
If you'd like to learn more about the egg industry and the Incredible Edible Egg trademark, you can visit the American Egg Board online at incredibleegg.org, and there you'll find everything from recipes, nutritional information, to interviews with egg producers from across the country. Okay, let's get into specifics. We've got this outlined. California passed a law saying the chickens, they need more room.
Right, that happened in 2008, and it was done by voter initiative. HSUS and other interests came.
Humane Society of the United States.
The Humane Society of the United States came into California, and this issue was put in front of the California voters, and it was passed. And to my understanding, it was passed by a wide margin in 2008. But what happened as a result of that is that California's egg production costs went up by about 20%. And egg producers in the state of California had to invest almost $400 million in their production facilities in order to bring them within compliance of the new proposition. So the egg producers immediately went to the assembly, the General Assembly there in California, and said, look, this new regulation, this Proposition 2, is going to put us out of business. Our eggs are going to be too expensive to export. Everybody else's eggs are going to come in here at 20% less than ours. And so we need to go back and create a second law that the Assembly passed in 2010, which said that in order to sell eggs from outside the state of California into the California market, everybody else in the country had to now comply with Proposition 2. And while that may seem logical to California voters and to the California egg producers, it is absolutely not the way that business is conducted in the United States. As the segment before said, it's a violation of the U.S. Commerce Clause.
Let's take this one step at a time. Doesn't California produce enough eggs for their own use?
No, California does not produce enough eggs for its own use, and not even close. Missouri, just to give you an idea, Missouri is one of the larger egg producing states in the country, I think second after the state of Iowa. Missouri produces about 1.5 billion eggs a year, and approximately a third of those eggs are sold into the California market.
So it's a big deal for Missouri producers as well.
It's a huge deal. 500 million eggs from this state, a third of our production is shipped out west.
And meanwhile, no other states have adopted this, so this is specifically for the state of California.
That's right. And so it's going to impact not only egg producers in Missouri, but in Iowa, in Kentucky, and in Indiana, and all of the states that have joined our lawsuit. And I actually believe that by the time this is done, there will be many, many more states that come on board this. As this case moves through the federal court system, I think we're going to see a lot of the agricultural states come in, because people are going to figure out over time that it's not just about egg production, that it could touch on corn, wheat, soybeans, anything in the agricultural markets, and frankly, beyond agriculture itself.
The initial investment you mentioned, the California producers' estimate of $400 million, that's to remodel their buildings to give the chickens more space in a confinement facility. Is that right?
That's right. And you know, it's very tough to get perfect estimates of what it would cost the Missouri egg production community, but we think it's probably upwards of around $100 to $120 million of investment here in order to comply with the new California regulations. So we're not voting for these folks who are now regulating Missouri's egg industry, and that goes to a core principle of the case.
Well, it seems to me like, and you're certainly the expert on the constitutional issues, there's a states' rights issue. Shouldn't California have the right to regulate the eggs sold in their state?
California does have the right to regulate the eggs sold in the state of California, and there's nothing about our lawsuit that objects to that or reaches into that principle. Missouri Agricultural very much believes in states' rights. But the issue is that the California General Assembly cannot be voted in or out by Missouri egg producers. It's fine for them to regulate their own industry, but not to regulate Missouri.
So tell us a little bit about the Interstate Commerce Clause. That's really what this is based on. Tell us how this works.
Well, the Interstate Commerce Clause, early in the country's history, there were trade barriers that were put up among the tobacco producing states, quite honestly, South Carolina, Virginia, states like this. And when those protectionist trade barriers went up between the original colonies, it became clear to the National Congress that that was an unworkable situation, that we were not a union of states at that point. They were operating as separate countries. And so when the Constitution was drafted, these types of trade barriers were explicitly prevented from occurring in our form of government.
It seems like to me we've got these trade agreements with Mexico, Canada, NAFTA, and other trade agreements with other parts of the country. This thing probably wouldn't be allowed under those international agreements, would it, to have this restriction?
Some of them would be allowed. Once you get into international trade agreements, things get massively more complicated, but there has always been a free trade agreement, essentially as a compact within the U.S. Constitution among the 50 states. And this regulation, Proposition 2, in conjunction with the Assembly Bill 1437, which is the law that applies it across the rest of the country. Our argument is that this becomes a de facto trade barrier into the state of California's market.
So other states have joined you. I believe you were the first, is that right?
We were the first. Nebraska, Oklahoma, Alabama, Kentucky, Iowa have come into the case. Other states are looking at it. But I really believe that while this case may have some initial challenges in the lower level federal courts, because the California courts, as one might understand and one might expect, have been somewhat hostile to this type of these types of lawsuits. As we move through the district court and then up to the Ninth Circuit and perhaps beyond, even to the U.S. Supreme Court, I believe that we are going to see more and more agricultural states come into this thing.
So this really could, you mentioned this earlier, some states are considering bans on GMO, or at least requiring labeling for genetically modified organisms. Florida, I think, has a restriction on sows not not using gestation crates. This really can be expanded to lots of different issues, can it?
Right. I mean, you can imagine a situation where, let's say that there was a California seed company. Let's say, I don't know, Pioneer had a headquarters in California. And the state of California said that for various reasons that are not provable, incidentally, but for various reasons, Pioneer seed was preferable to Monsanto seed. And so they said in order to sell soybeans or to sell corn into the California market, you had to grow with Pioneer seed. We would never allow that. You can imagine certain types of fertilizers, that if they deemed that certain types of fertilizers were preferable to the California market, agricultural producing states that didn't use certain production methods would be blocked from selling agricultural products into California. It's real easy to see how this case could become a much larger reach from the California General Assembly. In other words, we can't let the fact that this has to do with egg production and hens specifically confuse the broader topic that's at play.
And that's part of the confusion. You mentioned this earlier. Humane Society of the United States took this on, considering the chickens, they consider them to be overcrowded. So that restriction then, that is a personal opinion for those folks, becomes an issue throughout agriculture.
Right. Not only, I don't have an objection to Californians putting together their own regulatory policy, but this referendum policy not only it's going to affect California, it is now affecting the state of Missouri. And with one referendum vote in 2008, the egg production industry in the state of California was potentially put out of business, because there was not the internal debate that would usually occur in a General Assembly, where people got to bring the pros and the cons of an argument in front of a public body, and there was transparency. This was an amendment that was put on the ballot. And while people have a right to do that, we also see in a case like this how the lack of debate and the lack of transparency around an issue can have cataclysmic effects for an entire industry.
We're having some issues like this in Missouri. A couple of years ago, we had the Animal Care Facility Act, which was passed by the voter, which was going to be pretty restrictive. Governor and the legislature came back and reached an agreement that made it somewhat less restrictive. We've got a Right to Farm amendment coming up that is, I believe, going to be voted on in November. Is that right?
Well, that's true. And before we get to that, I mean, going back to this this agricultural law that was passed in Proposition 2 in 2008, there was a provision in the California law that was voted on by the people that the General Assembly of California, once that law passed in 2008, the General Assembly could not go back and amend it. So what happened with the puppy mill situation here, where it was passed by the people, and it was passed by a strong margin, but then Governor Nixon and the Republican majority negotiated out some fine points of that to make it a more workable document. That would not be allowed in this particular case, and that shows that it's a great example of the potential danger that this type of one-size-fits-all regulation, we negotiate it and then we never come back to touch it again, how dangerous that can be to an entire industry in any place in the United States.
And California's kind of known for that, having a series of these propositions on the ballot that are petition citizen initiatives, but maybe a little bit off the wall.
Well, California has a rather well-known history around these types of initiative petitions. But these types of things are not unique to California. They're all over the country, and we have had them here as well. But the danger is that these types of petitions can sink an entire industry, whether it be, you know, we had one related to wind production here in the state of Missouri. If a referendum petition came in and said 50% of Missouri's power has to be renewable in 12 months, and you cannot go back and revisit this. Well, the investor-owned utilities in this state could not possibly meet that standard. That's why it is so important that we rely on our General Assemblies for intelligent debate in a transparent environment where people can talk these things out, and we're not pegged and restricted to a single decision that is made on a single day and can never be revisited again.
And no doubt there was lots of money spent on both sides, probably in California. Lots of advertisements, very emotional appeals to the public in that regard.
Sure, no doubt about it. And one it can empathize with people who care about animals. I empathize with that as well. But agricultural production is Missouri's #1 industry, and we have to guard it with our best intention and our best intelligence.
Okay, can we talk about the Right to Farm amendment?
Sure.
I think that's an effort by agriculture to kind of protect themselves, but there's some folks in agriculture there's some division there. Has your office reached an endorsement or a position on that Right to Farm amendment? We
haven't come out yet, but I am very supportive of protecting agriculture in the state of Missouri. Agriculture is our #1 industry. This case that we're talking about in California shows how precarious the future of any industry, but agriculture among them, can be in the face of an initiative petition that is not thoroughly debated, and all you have is 100 words on a ballot title on the first Tuesday in November, and a yes or no vote that could have unintended consequences that are cataclysmic to the future of our state.
So we're looking at that possibility this November. What's the effect of the Right to Farm amendment? Will it protect farmers from that sort of event happening in the future?
Yeah, we hope that it does. The law is intended to make sure that that the right to farm is held up at the highest constitutional levels, and that this right has the highest constitutional protections among the first tier of rights that our Constitution upholds and protects. And so in an effort to make certain that these types of quick decisions that are not thoroughly debated don't come in and undercut the state's #1 industry, I am of course supportive of that.
So would it, I know there are some people anyway that would look at it, would it keep DNR from regulating agriculture in some way?
I don't think that it does. And DNR, the history of this state is that there is one recognized entity that can regulate agriculture, and that is the Department of Natural Resources. That should continue. Certainly, I don't think any industry should be totally unregulated. It is appropriate that we have certain setbacks, for example, for CAFOs. And that, I think, is also recognized by Farm Bureau and Cattlemen's Association. Nobody wants to do away with that. On the other hand, we don't want broad regulation by hundreds, if not thousands, of individual entities. We don't want circuit judges and associate circuit judges regulating agriculture. So when, a couple of years ago, we had the Arrow Rock case. Do you remember the Arrow Rock case? And there was a 15-mile buffer that was put around the CAFO near Arrow Rock. If you took that decision and you put it into every jurisdiction, well, there would be no land left in the state of Missouri for animal husbandry at all. A 15-mile buffer would totally eliminate animal husbandry in the state if it was placed in every single jurisdiction. And so that's a good reason why we don't want associate circuit judges regulating agriculture. These types of intelligent restrictions are critically important to the proper functioning of any industry. Department of Natural Resources should be allowed to continue its regulation, but after that, farming is a preeminent right.
What about counties, county zoning, county health ordinances, and that sort of thing? Would they be negated with this new law?
That is an open question that I think needs to be delved into. The amendment touches on Article 6 of the Missouri Constitution, and so certain counties would continue to have the right to regulate through their departments of health. Other communities, it is not as clear. So it's something that is worth a close look.
So the larger counties, more urban counties would be, but maybe not the rural counties that have tried to impact with health ordinances?
Have you looked at this? Is that how you read it?
I have friends that are suspicious that that's a problem.
Yeah, I've heard the dialogue about that. Ultimately, it's something that the courts would have to look at. My belief is that there certainly is no intent to eliminate the Department of Natural Resources from the regulatory priorities that have always existed in Missouri.
You mentioned that DNR is the regulatory agency, but I know there's some conflicts with the Environmental Protection Agency wanting to take over some of that regulation from the states. Isn't that? Do I understand that correctly?
Give me an example of what you're referring to.
Okay, if the EPA steps in with its very small waterways, seems to be an issue now, where they would regulate some waterways that DNR is not affecting now, some that would be wet weather watersheds, I guess.
Well, EPA is constantly reaching beyond its boundaries, and we find ourselves as often situated against EPA as on the same side of them. We talked off camera about this Chesapeake Bay situation where the EPA is trying to regulate point source pollution up through the Chesapeake Bay, and we have gone up into the Third Circuit, the federal courts up there, to restrict EPA's ability to do that. You know, for example, EPA in a given watershed does, under the Clean Water Act, have the ability to set a total maximum load limit for the entire watershed, but it's not for EPA to go farm by farm, acre by acre, and say to each individual farmer, you for example, that we're going to restrict your fertilizer usage. That is for the Department of Natural Resources to engage in. So EPA,
state by state.
State by state, but more importantly, farm by farm. Mm-hmm. EPA, under the Clean Water Act, can set totals that extend over a given watershed. But when you get down to the business by business, farm by farm, acre by acre level, that is not for Washington to regulate here in Missouri.
Important issue for Missouri. A lot of miles and miles of watersheds, the Missouri River, Mississippi River, big issues for us as well.
No doubt about it. In the Chesapeake Bay case, there are as many as 600,000 acres that may be taken offline if EPA has its way. And more scary than that is that EPA gets to go say which acres get taken offline. EPA can't come into Missouri, into the Missouri River watershed or along the Mississippi, and start picking out which businesses need to close, which businesses need to turn themselves down by 40, 60%, and which farms are operable. It's not the compact that we have with our federal government.
It's a real overreach by the federal government in that case.
That is our opinion.
We really appreciate your time. We appreciate your service to Missouri, Missouri agriculture. I think you're probably the highest ranking official I've had as a guest here on the show, so I really appreciate that. And trying to explain this to us, that it reaches beyond just the egg producers, and it could reach out to a lot of other people as well. So thank you very much. I'm afraid that's all the time we have for tonight. I'd like to say thanks again to Missouri Attorney General Chris Koster for being with us, and thanks to Joe Manhart of the Missouri Egg Council for allowing us to visit with her as well. And before we go, we'd also like to thank you, our viewers, for tuning in to Show Me Ag. We'll hope you'll tune in next time for another look at a topic touching rural Missouri. For everyone here at CAMOS and myself, good night. We're also very interested in what you have to say. So if you have feedback you'd like to share with us, you can email us at showmeag@camos.org or find us on Facebook.